Every couple of years, our water bill goes up, and many people don't understand why, or even if they have a voice in the decision. We just complain and pay the bill. Across America, the rules around water rates vary significantly from state to state. For regulated water utilities, there is a formal legal process behind a rate increase. The company has to justify what it's asking for. State regulators have to review it. And in many states, there are people whose entire job is to represent the public inside that process. One of those people is Darryl Lawrence, the consumer advocate for the state of Pennsylvania. I spoke with him to pull back the curtain on how this process actually works and what it means for anyone who's ever looked at a water bill and thought, how on earth did we get here?
I'm Darryl Lawrence. I'm an energy attorney by training, and I also currently have the honor of serving as the consumer advocate of Pennsylvania.
So you are the voice in the room for the consumer.
Yes, I would say myself and the entire team of folks here at the Office of Consumer Advocate, or the OCA as we're generally known.
Rate cases are complex. The filing itself can run hundreds of pages. Darryl walked me through what contributes to the request for a rate increase.
The utility is the one who is in control of when they decide to file a rate case.
Okay.
And generally, they will decide based on their current level of profits. When those profit margins become too low, in their opinion, they will seek rate relief. And so they will make a formal filing with the Public Utility Commission. And the filings are very voluminous, often several hundred pages, accompanied by expert witness testimony from the company to explain in detail why they're seeking a rate increase at this time.
And in my community, there's been a lot of infrastructure repair and replacement because we have a lot of old pipes here. Is that a big part of why they would go back for a rate case, or is it more operational?
Now, spending on infrastructure is really a main driver of almost every rate case you will ever see. It is the large amount of money that the utility has already spent on new pipes, new infrastructure, and the amount that they plan to spend, let's say, in the coming year.
And that's where it gets complicated. The utility isn't just projecting what they plan to spend, they're also recovering what they've already spent. Past investment and future projection bundled together into the number on your bill. Once the utility files, the legal clock starts, and the process begins that most customers know nothing about. There are formal mechanisms for the public to participate.
Once the utility files a case, the public has a number of options as to how they wish to be involved. Individual citizens can actually file a petition to intervene in the case. They can also file a complaint to become a party to the case. Normally, for citizens, the best possible avenue is to participate in a public input hearing.
I attended one of those hearings myself, and I watched more than half the room choose to speak off the record. I understand the instinct. It feels safer, less formal. But there are real, lasting consequences to that choice.
It is extremely important for people to be heard on the record. People who choose to speak off the record, their remarks are not recorded. Their remarks do not become an official copy of the evidentiary record. And why that's really important is when the time comes for us to file our written testimony in the case, one of our witnesses will basically provide a summary of all of the public input hearing testimony that is part of the transcript, it's part of the evidentiary record. And we can rely on that evidence to make our arguments in the case.
I would say more than half of the community, if not 70% of the community who spoke, was off the record. And I was listening to it thinking, how are they going to remember what the community says, so if they don't actually record it?
The next time that utility comes around and my office is there advocating for these public input hearings, the commission and the administrative law judges will very vividly remember what happened the last time.
The implications of that run in both directions. Go on the record, and your words become part of the evidentiary case. something the OCA can cite and build from. Stay off the record, and your testimony, however passionate, carries no legal weight in the proceeding. And low turnout isn't just a one-time loss. It shapes how the next case gets structured before it even starts. That dynamic can work the other way. Darryl has seen it.
In 2006, one of our natural gas utilities filed for a rate increase. They filed for a very controversial rate design where they were actually proposing to charge people for a regular amount of natural gas, whether the customer actually used it or not.
Oh.
In utility jargon, it's called decoupling. What happened is, first of all, the company, in my view, did a very poor job of explaining what they were trying to do. And also it got very widely publicized in local newspapers and the media. And at the first public input hearing for that case, there was well over 1,000 people showed up.
Wow.
And somewhere around 125 people testified on the record. As you can imagine, almost all of them in opposition to what the utility wanted to do. And the pressure from the public was so great that the utility dropped that proposal. They continued with their rate case, but they pulled that proposal out of the rate case.
So we really can have an impact if you mobilize and go on the record. There's one more barrier that keeps people from testifying, and it's worth addressing directly.
Sometimes when the judge gives his speech in the beginning about what's going to happen and how it's going to happen, he has to inform people that when they testify, they are subject to cross-examination. The company attorneys or other attorneys can ask them questions based on their testimony.
That happened in our case. There was an attorney there asking questions.
Yeah, and sometimes that gets consumers a little on the apprehensive side. Well, I don't know if I want to do this. After I listened to the judge and he said, I could be subject to cross-examination. I'm not sure that I want to do this. And then they don't sign up. But I'm here to tell you that 90% of public input hearing testimony witnesses never get a question.
After the hearings close, after the testimony is in, the case moves into its final phase.
Towards the end of the process, there will be a formal evidentiary hearing for the expert witnesses. They would be called to the witness stand to defend their testimony. Then there would be a period of time for all of the parties to submit their legal briefs in the case. After those legal briefs are submitted, the administrative law judge or judges assigned to the case will decide all the issues in the case, and they will provide that decision to the Public Utility Commission as a recommended decision. After that, the parties to the case have a chance to either agree or disagree with the recommended decision. The commission has approximately 60 days to decide the case. The whole process from the day the utility files the rate case until the day that the Public Utility Commission issues its final order, all of that has to take place within 9 months. It is a legal time frame. The commission will issue its final order at a public meeting, and then generally within a day or two, a formal written order will come out.
9 months start to finish, but many cases never reach a commission order. They settle, and a settlement can produce outcomes that a commission order legally cannot. Phased rate increases, rate freezes, expanded programs for low-income customers. None of those can be ordered by the commission. They can only be negotiated.
It really is a process. It's one of the reasons why you will often see these cases end in settlement. If a settlement can be reached that is in the public interest, that benefits ratepayers for any number of reasons, maybe the company will agree to take a much smaller rate increase. The company may agree to create or expand new programs for low-income customers, phase in rates over a period of years, or having the utility agree to a rate freeze for a period of years. The results are better than what could happen in a fully litigated case.
This process is not simple. The filings are hundreds of pages. The timeline is compressed. The utility has attorneys and expert witnesses. Most of the customers have none of that. What they have is standing, a formal legal right to be heard on the record in front of a judge in a proceeding that has real consequences for the number on their water bill. If you want to understand how to use it, the Office of the Consumer Advocate has free resources for you at oca.pa.gov. And if this conversation opened something up for you, share it with someone in your community. The more people who understand how this process works, the more people can actually participate in it.